subpoena or do anything of that nature. But would they have to make the complaint in writing? And I don't think there'd be any prohibition about calling that individual if you have questions.
Well, you don't call names, of course.
But the one thing we do, one thing before going forward, Mr. Von Cannon, keep in mind is if these things come up, these are being some new ground, and we'll take each issue as we come to it and make sure that we do a little bit of research because we just want to do it right.
Should we develop a set of procedures to handle each one the same way?
Absolutely. Uniformity is the key.
So I think
everybody gets treated the exact same procedure.
So I think that ought to be one of our first things is develop some procedures.
In the first 2 meetings, if we can start getting that put together, we'll be doing real well.
Meetings in public, or do we have any authority to close the meeting in discussion? Certain, of course, we're not going to name names naturally, but still, it doesn't take a rocket scientist sometimes to figure out should those meetings be at open meetings or closed meetings. In other words, could we ask the media to?
Well, and let me elaborate here. Let me explore where I see this going, and I'll use myself or Commissioner A, B, C, or D, or any elected official. 6 weeks before an election, somebody signs a complaint and says that they're doing something, may not have any valor to it, but it's something that you have to do. That will be headline news and will affect somebody negatively when it could be, and that's extremely wrong. And I want to be a part of any of that. That kind of thing, if it's got valor to it, and it should be, but I truly believe that it's unethical as much as anything to destroy or hurt somebody when it has no factual basis whatsoever.
How about I do this?
That's why I'm wondering if public meetings, even though you don't name names, still, people can put 2 and 2 together on occasions and figure out who you might be talking about, and that's not right either. Because you could ruin someone's reputation by innuendos and that sort of thing.
When I put your packets together, let me have your written answer to that to make sure we're right. My initial gut is under the Sunshine Act. There's no specific exclusion for that unless we're talking about potential litigation from attorney-client. My gut is no. But let me just give you a written opinion to make sure, because a lot of times, and this is where the statutes are a little funny to read sometimes, because you'll read the Sunshine Act and it says one, or Open Meetings Act, it says one thing, but then when you read the actual, not the books put together by CTAS, but the actual statute, sometimes there'll be an exception in there specifically for that won't be picked up in the Sunshine Act. Because the Sunshine Act was passed in '74, this was passed in 2005. And the legislature, a lot of times, they should, but when they'll put an amendment into something in the 2005 statute, they never denote it in the '74 statute, so you won't see it.